Welcome to the Special Education News Roundup. I am your host, Jennifer Price, and this week I'm going to be talking to you about expulsions with the additional concept of manifestation determination hearings. Now, the student in this case is GR, and GR was an 11th grader who attended a public high school where he participated in the automobile mechanics and bodywork program. Now, one night, GR left a Smith & Wesson Extreme Ops knife in the back pocket of his pants one day after work. The next morning, he put those same pants on when going back to school, completely forgetting that the knife was in his back pocket. Well, once he arrived at school, he got into a dispute with someone else at the school in the parking lot. A security officer went outside to see exactly what was going on, and during that officer's investigation, the knife was discovered on GR, and GR then turned it over to the school. So as a result of GR possessing a weapon on campus, he was in violation of the school's no weapon policy, and this policy subjected him to discipline, where he was ultimately expelled for 1 year. Now, the parents requested an expedited due process hearing where the issue became whether the school was actually obligated to conduct a manifestation determination hearing. Okay, so at this point, you haven't heard me say anything about GR actually having a disability or receiving some kind of special education services. That's because he wasn't receiving special education services, but there was a thing in the law about whether a school knew or should have known about a child having a disability. The parents were making the argument basically that the school had knowledge that GR did actually have a disability based on prior email exchanges they had with him about his behavior in the 8th grade. Okay, so I think you can see the writing on the wall for this case. One, a few emails about 8th grade conduct doesn't exactly translate into knowledge of a disability 3 years later when the child is in the 11th grade. Two, which I didn't mention beforehand, was that his grades were actually good. And while grades don't actually equate to a disability, they do become relevant when you're trying to impute knowledge about that disability upon the school. So the court didn't go forward and wasn't willing to actually overturn the hearing officer's decision to maintain the 1 year expulsion from school. So here's the thing. The most glaring issue for me when I read the case was that the court didn't even mention anything about whether it would have even made a difference in the first place. So I'm bringing this case to your attention just to discuss a few issues about the manifestation determination hearings. The purpose of a school holding a manifestation determination hearing is to determine whether the conduct being disciplined is really a manifestation of that child's underlying disability. Okay, so GR brought a knife to school. The reality is, in some jurisdictions, bringing that knife on school property would probably be considered a weapon. Now, this was a folding knife, it wasn't a spring-loaded knife, but still some jurisdictions may still consider this type of knife to be a weapon on school property. And if so, it is highly unlikely that a hearing officer is going to rule that a child having it in his possession was actually a manifestation of that child's disability, regardless of the disability. I haven't seen it here in Pennsylvania, I haven't read about it in other jurisdictions, but as soon as I do, I certainly will bring it to your attention. And while manifestation determination hearings work to keep the school honest, so to speak, and require them to do their job if they're going to expel your child, if the expulsion is for bringing a weapon on school campus and you hire a lawyer, have a real conversation with that lawyer about how that lawyer is going to connect the dots between the weapon the child brought and the child's disability. Until next time, friends.